Now let's proceed when non-lawyers may practice law. Although it sounds odd that a non-lawyer can practice law, we must always remember that general rules admit of exceptions, such as this case in point. General rule is that a non-lawyer cannot practice law. Only lawyers can practice law. Only persons duly admitted to the bar and in good and regular standing are entitled to practice law, except in the following cases: in criminal cases before the municipal trial court, in civil cases before the MTC, in civil cases before any court, and before a cadastral court. Did you know that law students may perform limited practice of law? The Supreme Court en banc on June 25, 2019 adopted and promulgated AM number 190324 SC Rule 138A, Law Student Practice, otherwise known as the Revised Law Student Practice Rule. This revised rule is an amendment to the existing provisions of Rule 138A of the Rules of Court. A salient feature of the revised rule is that a law student must now be certified under the Clinical Legal Education program of his law school in order to be able to engage in the limited practice of law. Now, what is this Clinical Legal Education Program, or CLEP? It is the experiential, interactive, and reflective credit-earning teaching course with the objectives of providing law students with practical knowledge, skills, and values necessary for the application of the law, delivery of legal services, and promotion of social justice and public interest, especially to the marginalized, while inculcating in the students the values of ethical lawyering and public service. How will law students be able to perform this limited practice of law? Under the rule, initially a law student shall apply for and secure a level 1 or 2 certification in order to be permitted to engage in any of the activities under the Clinical Legal Education program of his law school. The basic distinction between the two levels involve the minimum academic requirement the law student has successfully completed. For level 1 certification, first-year law courses, while for level 2 certification, third-year law courses. After the law student has successfully secured his certifications, subject to the supervision and approval of a supervising lawyer, the law student practitioner may, for level 1 certification, interview prospective clients, give legal advice to the client, negotiate for and on behalf of the client, draft legal documents such as affidavits, compromise agreements, contracts, demand letter, possession papers, and the like, represent eligible parties before quasi-judicial or administrative bodies, provide public legal orientation, and assist in public interest advocacies for policy formulation and implementation. For level 2 certification, a law student may perform all activities under level 1 certification, assist in the taking of depositions and or preparing judicial affidavits of witnesses, appear on behalf of the client at any stage of the proceedings or trial before any court, quasi-judicial or administrative body. In criminal cases, subject to the provisions of Section 5, Rule 110 of the Rules of Court, to appear on behalf of a government agency in the prosecution of criminal actions, and in appealed cases to prepare the pleadings required in the case. Additionally, a law student practitioner may also sign briefs, pleadings, letters, and other similar documents which the student has produced under the direction of the supervising lawyer, indicating the law student practitioner's certificate number. In criminal cases before the MTC, it is only allowed when these circumstances are all present. In a locality where a duly licensed member of the bar is not available, the judge may appoint a non-lawyer who is a resident of that province and of good repute for probity and ability to aid the accused. Next, in civil cases before the MTC, a party may conduct his case or litigation in person with the aid of an agent or friend appointed by him. In civil cases before any court, a person may conduct his litigation personally, but if he gets someone to aid him, that someone must be an authorized member of the bar. Before a cadastral court, a non-lawyer may represent a claimant before the cadastral court. Did you know? A non-lawyer may represent a party before the Department of Agrarian Reform Adjudication Board or DARAB, according to the 2021 DARAB Rules of Procedure, Rule 8, Section 44. A non-lawyer may appear before the DARAB or any of the adjudicators if he or she 1. Represents himself or herself as a party to the case. 2. Represents his or her farmers' organization or its members. Remember, he or she must show proof of authority from the organization or its members, or duly signed by its chief executive, president, head, or chair. 3. Is a law student. And last, a DAR legal officer. He or she must have the authority and under direct supervision and control of the Chief Legal Division. Another instance when non-lawyers may practice law is when a person appears before the labor tribunals. Article 228 of the Labor Code authorizes non-lawyers to appear before the National Labor Relations Commission or any labor arbiter in representation of the organization or members thereof. More so, the 2019 NLRC Rules of Procedures, particularly Section 6 of Rule 2, provides the conditions when a non-lawyer may appear before the NLRC or labor arbiter in furtherance of Article 228 of the Labor Code. First, when he or she represents himself or herself as party to the case. Second, when he or she represents a legitimate labor organization which is a party to the case. Third, when he or she represents a member or members of a legitimate labor organization that is existing within the employer's establishment who are parties to the case. Fourth, when he or she is a duly accredited member of any legal aid office recognized by the Department of Justice or Integrated Bar of the Philippines. And fifth, when he or she is the owner or the president or any other authorized person of a corporation or establishment which is a party to the case. How are non-lawyers subject to such limitations? To answer such important query, let's delve more into the case of Philippine Association of Free Labor Unions or PAFLU versus Binalbagan Isabela Sugar Company, which illustratively exhibited the limitations on the appearance of non-lawyers before the courts. First, that such non-lawyer must confine his work to non-adversary contention. That he should not undertake purely legal work, such as the examination or cross-examination of witnesses or the presentation of evidence. In the case of PAFLU versus Binalbagan, the Supreme Court cited the provisions of Section 5, Letter B of RA number 875, which allows the parties to be represented by non-lawyers. However, the same provision provides that only the court or hearing officer be allowed to examine and cross-examine witnesses on behalf of the parties and to assist in the orderly presentation of evidence, thus making it clear that the representation should be exclusively entrusted to duly qualified members of the bar. Second, that his or her services should not be habitually rendered. In the same case, it was alleged that the non-lawyer is engaged in the habitual practice of law before the courts. The Supreme Court took note of this serious situation, demanding corrective action that courts should actively pursue and enforce by positive action to that purpose. And lastly, he should not charge or collect attorney's fee. The court ruled that the permission for a non-member of the bar to represent or appear or defend in the said court on behalf of a party litigant does not by itself entitle the representative to compensation for such representation.